All right, well, everybody, welcome. Thank you for joining us here today. My name is Sam Adair. I'm one of the partners here at the law firm of Graham Adair, and I'm joined by my partner, Chad Graham. And just a couple of things. We are going to be recording this session, so if you do not want to have your name show up on the side or your image show up, it's probably a good idea to go ahead and leave this now, and we'll make a recording of this available on our YouTube later. The other point that I want to make, or a couple of points, is that while we are going to be answering questions that were submitted, we're doing that based on limited information. And so nothing that we say today really constitutes legal advice. It's important that if you have a question that deals with specifics about your situation, that you discuss that with an attorney. If you don't have an attorney, Chad and I would be happy to talk to you about starting an engagement. But definitely, everything today is provided for informational purposes. Any specifics about your case will need to be pursued with an attorney. As we sort of get started today, we received a significant number of questions that we want to go through and address. And so we will be doing that. These questions were taken directly as they were submitted. We did not edit any of those. And so we will be responding to them as best we can based on the information that we have. And so I think with that, I'm going to go ahead and throw over to Chad, and we're going to start with that first question.
Fantastic. Thanks, Sam. The other thing I would say is, as we're going through this, you may have questions that come up that occur to you. This presentation is scheduled to go for an hour. And so if we get done a little early, we can get to additional questions. So if you have a question, go ahead and put it in the chat, and then we'll get to those at the end as we have time.
And I would say if you want to submit those questions, not entirely anonymously, but a little more anonymously, they can be sent directly to Chad and I. They don't have to be sent to the whole group, I think. Might be a way to do that.
Great. So here is the first question. The first question is, currently L1B visa holder. My company got Graham Adair to help with this, exclamation point. So I think that's good news. I think everything went well. From Canada, we'd like to pursue the next step and apply for my green card, and would like to know as much information as possible on what this process will be like. The first thing, this is kind of a broad question, which is great. The first thing I would say is, when you're with a company who's sponsoring your immigration benefits and it's time to go for a green card, or you want to start a green card, the best thing to do is to talk with your manager or even someone in human resources about it. Often companies have a requirement that you spend a certain amount of time with the company before they'll pay to begin your green card process. A lot of times that's 12 months. So you may want to find out how long you need to wait for that. The second thing I would say on this is to get specific about what the process probably looks like for someone who's an L1B. Someone who's in an L1B status is most likely going to go through the employment-based green card process in either the second preference category, EB2, or the third preference category, EB3. And because of that, there is a requirement that it go through PERM labor certification first. And so the green card process is really going to be a three-step process. First is the PERM labor certification. Second is the I-140. And last is the I-45. That's the actual green card application. And a lot of people ask, when can I include family members, a spouse, and children with me in the green card process? That's that last step. That I-485 application is when you include family members. So again, three steps: PERM labor certification, I-140, and then I-485.
This next question states, after the I-140 approval, how does the green card renewal work? Is the citizenship a better option? So it's a great question. The green card renewal is a fairly straightforward process. The only downside of it is that it takes a really long time. The application to renew a green card is called an I-90. It can be submitted online. It does require that biometrics be taken in person. That typically happens a few weeks after the application has been filed. It's anywhere between 8 to 12 weeks in most cases. And then the processing of that application can take anywhere from 12 to 24 months. So it can be a fairly long process to get the renewal. The second half of this question is about citizenship. Citizenship is certainly an option. It's also a fairly straightforward application. It's a significant, I think, personal decision about whether or not to apply for citizenship in the United States, but it's certainly something that is available to people. That's done by filing an N-400, and the application processing time is about 12 months from the time you file that to the time that you're going to be granted your naturalization, your citizenship.
The third question here just says PERM process EB2 timeline. So the timeline for PERM labor certification has gotten longer in recent history. Right now, from start to finish, we're looking at anywhere from 12 to 18 months. And a lot of that is due to the time that it takes to get a prevailing wage determination back from the Department of Labor. I remember in the good old days where it used to be, a few days or a week to get that piece of it back. But now that part's taking about 6 months. And so once that's done, then the actual PERM labor certification is filed with the Department of Labor. That process is taking anywhere from 9 to 12 months. And then assuming the case is not audited, then it would be certified and you could move forward with the rest of the process. If there is an audit, typically that adds a little bit of time, not a terrible amount of time to the overall process. Now I'm actually going to show my, I'm going to share my screen for a second to show you guys something, the visa bulletin. So I'm sure some of you are familiar with the visa bulletin, but for those who are not, I just kind of want to show you what we're looking at here. So for the second preference category, you can see here in where it says second, so the second row here, these dates here, what this means is if you're from a country that's listed across the top here, so China, India, Mexico, Philippines, then you look at that column. If your country is not listed there, then you look at that first column, the all chargeability areas except those listed. So depending on the country that you were born in, the process can be significantly longer or significantly less. If you compare, for example, the all chargeability areas column that has a date of 8th of July 2022 compared to India, the 1st of January 2012, you see there's roughly a 10-year difference there in the potential time that it may take to get a green card. So a lot of this comes down to the country you're from and the preference category that you're from. We're going to talk a little bit more in detail about some of this stuff, so I won't go too much, but I wanted you guys to understand what the visa bulletin is. It comes out every month and the dates are always kind of shifting.
Great. So we've got another green card question here, and it states, I'm currently on H1B with EAD received after filing I-485 on EB2 when dates were current and then got rolled back. I was in L1A visa from 2010 to 2013. Is there any possibility of moving my green card processing in EB1 category? So it is, it's really hard to advise specifically on this, but I'm going to talk a little bit specifically about the requirements for the EB1 classification. And presumably because we're talking about the L1A here, we're talking about a multinational manager, or the EB1C as it's known. And that requires that an individual will have worked outside of the United States for 12 months in a managerial or executive capacity, and that they move to the United States with the same employer to a U.S. entity or related company, and that they work in an executive or managerial capacity. The L1A does not hold the exact same requirements, similar but not the same. You don't have to have worked outside of the United States in an executive or managerial capacity. You could have worked in a specialized knowledge capacity. And so it's important that we, make that distinction. And also here in this question, it's not entirely clear if the individual is still employed with the same company that they were back in 2010 to 2013. So it's a possibility. There may be an option there, but that's something that you're going to have to explore a little bit more with an attorney.
Okay, next question. For a TN visa holder, is it possible to apply for a green card while on TN? I will have to renew my TN visa in 2 years. Will the green card process complicate my renewal of TN when the time comes? Yeah, this is a good question. And the first thing I want to talk about here is the difference between a dual intent status and a non-dual intent status. What I mean by intent is when you come in on a non-immigrant visa like a TN, it's assumed that you're not planning to stay here long-term, that you're going to stay here during the duration of your work permit and then eventually return home. So that's the non-immigrant intent piece. Now, when you start the green card process, that introduces immigrant intent, meaning you do plan to stay here for a long time. Now, there are some statuses like H1B that are considered dual intent, meaning you can have the intent of being a non-immigrant and also being an immigrant at the same time and having those processes move in parallel, and there's never a conflict. Now, a TN is considered a non-dual intent status, meaning that if you're in a TN status and you begin the green card process, you file an immigrant petition, there does a conflict is created there. Now, that's not to say that if you're in TN status, you can't go and apply for a green card. You can do it. It just can be a little bit complicated because in this scenario that we're talking about here, if an immigrant petition is filed for this individual and then they've shown their immigrant intent by doing that, then if they go and apply for a TN visa again, then they're displaying a non-immigrant intent, and that can create a conflict that we would definitely want to avoid. So again, it's something that can be done, but it has to be done very carefully.
The next question also deals with the green card, and it asks specifically about the timelines for the PERM and the I-140. And so right now, what we're seeing in PERM processing times, and I'm going to talk broadly about what it takes to get a PERM, but when you start a PERM application, you first have to submit to the Department of Labor a prevailing wage determination request. And right now, those prevailing wage determination requests are taking on average about 6 months, which is an improvement from what we had seen over the last 12 months or so. Once you get that prevailing wage request, you can proceed with the next steps of doing the test of the labor market, which takes about 2 months. And then after that, you submit the application to the USCIS to the Department of Labor. And it takes right now about 12 months to get a certified PERM application from the Department of Labor. So in total, you're looking at something like 18 to 20 months to get the PERM completed. Once that PERM is certified, you can file the I-140. That can be done with premium processing. If you don't use premium processing, it takes about 10 months to get a decision on an I-140. So it takes anywhere from 15 days to about 10 months to get the I-140 approved. And this slide didn't ask for it, but just really briefly, the remainder of that green card process is going to be determined by your priority date when you can file the adjustment of status. But once your priority date becomes current and you can file that adjustment of status, you're looking at approximately 12 months or so from the time you file the AOS to when that green card is going to be issued. So in total, you're probably looking at about 3 years to process a green card, but you have to factor in the visa bulletin and priority date limitations, and that could add considerable time to that process.
Great. All right, so the next question here, still talking a little bit about the green card process and the intermixing of a TN visa. It says currently going through PERM process and holding TN visa. We talked about this a little bit a couple of slides ago, but I will just add that that is actually fine. The PERM process is not considered an immigrant petition. It's a requirement that the Department of Labor has for companies initiating the green card process for employees going through the second preference or third preference category. So a lot of people do go through the PERM process, and it's not considered a direct conflict on that TN visa. Now, once the PERM is approved and then we move to the I-140, once that I-140 is filed, that is considered an immigrant petition. And what we're saying by filing that I-140, or what you're saying by filing the I-140, is I've changed my intent from a non-immigrant intent in TN status, and now I'm moving to an immigrant intent with my green card process. And as long as you can continue that process through the green card, you're fine. If for some reason you need to reassert that TN and create that non-immigrant intent again, then you could have a potential conflict.
Great. This next one is a question, and well, it's really more of a statement, but questions about keeping GC alive. And I'm going to make some assumptions here as I answer this or respond to this prompt, but I'm assuming that this is for someone who has been issued a green card, and they're wondering what they need to do to maintain their green card status. And the biggest thing that you need to do to maintain green card status is reside in the United States. If you leave the United States for a period of more than 6 months or 180 consecutive days, there is a presumption upon returning to the U.S. that you've abandoned your permanent residence. So if you have a green card and you're making trips internationally, you want to limit those trips to be less than 6 months. If you have a trip that's going to exceed six months, you want to apply for a re-entry permit before you travel outside of the United States. Other things to do to maintain green card are not get arrested, avoid criminal activity here in the United States, and that will also help ensure that your green card will not be revoked in the future. But the biggest thing is if you are traveling, limit those trips. If this question was about what you can do to keep a green card application alive if you change jobs, that's a different question, and that's probably something that we're going to want to talk about a little bit more later on. So with that, I'm going to go ahead and throw that to Chad.
Great. We've had a lot of people join, and so I just want to pause for a second. This presentation is scheduled to go for an hour, so for another 40 minutes. If we get through these questions and we have time, we will address other questions that are put into the chat. So if you have additional questions, feel free to put them in there and we'll get to them if we can. Okay, the next question says, what happens in the hypothetical case that your employment ends during either the I-140 or I-45 phase of the application process? Say the company I am currently employed at goes down, many startups fail, yes, that's true, or I am the victim of unexpected layoffs, common in the biotech industry. Am I correct that while I would lose the O1 status either way, if I self-petition, the green card process would not be interrupted, while it would if it is sponsored by my current employer? Okay, so there's a lot there. The first thing I'll address here is the self-sponsor versus employer-sponsor scenario. So most people going through the employment-based immigration process are going to have their employers sponsor not only their immigrant or non-immigrant visa, but also their green card process. So yes, to answer that, if your employment terminates during the I-140 or I-485 phase, then you would need to start that, you potentially would need to start that process over. If it's terminated at the conclusion of your I-140, let's say the I-140 is approved, then yes, if you move to a new employer, that new employer would need to file a new PERM and a new I-140. The good news is, because your previous I-140 was approved, your priority date stays the same. So if you remember that visa bulletin I was showing you, basically, when you get a priority date, that kind of marks your place in line for how long you're going to have to wait. And so the good news there is you would keep your place in line as long as your I-140 is approved. If your I-485 is filed and pending and has been pending for at least 6 months, then your green card process is potentially portable. So which means if you move to a new company and are in roughly the same position that was sponsored by the previous employer, you can potentially continue that green card process with the new employer. Again, that I-485 has to have been pending for at least 6 months. Now, if you are self-sponsored, and the ones that we typically see here are the national interest waiver under the second preference category, or EB1A extraordinary ability under the first preference category. Then if your employment is terminated, you're correct that you would be able to maintain those processes going forward. If you had an I-485 based on either of those processes, you would be able to continue to move those forward even if you are laid off.
The next question is on slide number 12, I believe, Paul. And it asks, what are the alternatives to the H-1B? And I'm glad that this didn't ask what are the good alternatives to the H-1B, because the short answer is that there are none. But that said, the H-1B is obviously sort of a very broadly used and sought after non-immigrant visa in the United States, because it allows for very much sort of an open application process. Many of the other non-immigrant visa categories that I'm going to talk about have specific requirements that limit who can apply. And so that said, some of the alternatives that exist to the H-1B are L1s, which require having previously worked outside of the United States for an employer and then a transfer to the US to work for a related entity or subsidiary. The TN visa, which is only available to citizens of Mexico and Canada. The E3 visa, which is available to Australian citizens. The O1 visa, which is available to individuals who have extremely high qualifications and can meet pretty substantial criteria that we'll discuss a little bit more later. The J1 is a visa category that is good for people who are coming on sort of temporary exchanges here to the United States. And then also there is an H1B1 category that is only available to individuals who are from Chile or Singapore. So there are some other work visa options, but none of them are really great. And for that reason, we do see a lot of individuals who will continue to pursue F1 visa status, pursue an additional degree, work on OPT or CPT while they continue to apply for the H1B lottery. So no great options there. There's not an easy solution, but there are some alternatives that are available to the H1B.
Okay, so this one's talking about visa bulletin and retrogression. It says, hi, I'm a potential immigrant from India on EB2 and have a priority date of August 2021. Looking at the rate of processing green cards, it's evident that it will take decades, luckily not decades, but I know it feels like that, before my priority date becomes current. I wanted to ask if there's something that will help people in a similar boat, or if you foresee a change in the immigration rules in the future that might help people like us. All right, so the good news is I'm gonna go back. I'm gonna share my screen for a second here and go back to the visa bulletin so you guys can see what we're talking about here. All right, so I think it was EB2 India. So we're looking at this box here. If you go to the first column where it says second, and then scan over to where it says India, the effective date there is January 1st, 2012, which saw some decent a little bit of forward movement from the September visa bulletin. But you're right. I mean, it's over 10 years based on this current visa bulletin estimate. So it is a long time, and I don't want to downplay that. That's, it's something that's awful. And I do hope that at some point we get legislation that will help that. Right now, the way the law works, there's 140,000 immigrant visas available through the employment-based process every year. And if a country, if people from a certain country apply for more than 7% of those 140,000, that's where you start to get retrogression. And then as you exceed that year after year after year, which is what we've seen in India, that line starts to get pretty long. And so there has been discussion, and I can't say that it has really advanced anywhere, but I know that it's on people's minds at least, that they might want to get rid of that 7% rule. And if they do that, then basically, these dates that are kind of all over depending on the country you're from, it would be like the water leveling out for everybody. And it wouldn't really matter what country you're from. If you're in the second preference category, it's going to be this date. If you're in the third preference category, it's going to be that date, regardless of country of origin. So that's one thing. The other thing I wanted to talk about is, especially for people from India, something to be thinking about is whether you can get into the first preference category. Now, the first preference category, and Sam's talked about this a little bit, it's reserved for people who can demonstrate very high achievement in their field. And, it requires, typically we see people that have a PhD applying for EB1. It's not required, but a lot of times the things that you do in a PhD program are conducive to meeting the requirements for the first preference category. There are things like filing or writing articles and having articles published, having those articles cited by other people in the field, having a patent or writing a book chapter, winning awards, having memberships in organizations, things like that. So there are things that that can be done to meet those objectives. And I would say that if you're interested in knowing what they are, and you think, maybe you're kind of already on the track, and it would take you maybe a couple more years to really build up a better set of credentials to qualify for EB1. Again, especially from India, where you're looking at a potential, 11 or 12-year wait, whereas in the first preference category, now the October visa bulletin doesn't look great, but it tends to be significantly better in the first preference category, even for India. We're talking like 7-8 year difference usually. It might be worth taking a couple of years to build up those credentials, qualify for EB1, and then file a new application in the first preference category.
Great. Paul, let's go to 10. And Chad, I'm going to issue a challenge to both of us. We We're about a third of a way through the questions and about a halfway through our time right now. So we may need to work on brevity, which as lawyers can often be a challenge for us. All right, so this is a question in 3 parts. Question 1, green card application on a TN visa. At what times are you not allowed to leave the United States? Typically, about 90 days before the adjustment of status is filed, and then once the adjustment of status is filed, you won't want to travel outside of the US again until your advanced parole document, the travel document that comes as part of the green card process, has been issued. Question 2 is, can your job title status at current company change when going through the green card process? Yes, it can. However, you're going to want to evaluate that pretty closely with an attorney to ensure that the change is not material to the underlying application, and that you are in a position where, if it is going to have an impact on the green card, that both you and your employer are prepared and understand what that means. Question 3 is timing to process green card for Canadians and or generally from start to finish. Roughly about 3 years is what it takes to get through the green card process if you don't have any type of priority date issue.
Correct. H1B Alternatives. Hi, I'm currently on my F1 visa and would like to explore a few other options if the H1B visa doesn't get through the lottery system. Sam talked about some of these things already, so I'll quickly go through and review a few. A lot of people, if they're not able to get an H1B, will apply for another F1 program. So like if you did a bachelor's degree, then you can apply for a master's degree, do another F1 program. And the nice thing is, as you move to those higher level degrees, you qualify for another round of optional practical training after you graduate. So either 1 year if you're in, certain degree fields, or if you're in a STEM degree field, science, technology, engineering, or mathematics, you can get 3 additional years. So that's one thing. Sam walked through the O1. Another one to think about potentially is a J1. This is a intercompany, or international exchange type of visa. And I won't go into a ton of detail on it, but just know that it's an option. The last one I would say is to look at a potential self-sponsorship. We talked about, I alluded to the national interest waiver previously. This is one where you demonstrate that what you're doing is in sort of a broad scope national interest to the United States. You can file a green card application within the second preference category. And as long as you're from a country where it looks like you're going to have a current priority date, that could be a good option to consider as well.
The next question that I have is a broad one. How do I permanently move to the U.S. from a European country? And to kind of answer this, I want to talk about it sort of from a high level. U.S. immigration requires that for somebody who's coming to the United States, that they have some sort of a tie that allows them to qualify for a status. And there are sort of 3 major options that people have when looking to come to the United States. One is family members who are U.S. citizens or permanent residents. They can potentially sponsor somebody to come to the U.S. The other is through employment. If there's an offer of employment or you're studying in the United States, you can get a student visa through your institution and then ultimately seek employment after that here in the U.S. And the third option would really be through the diversity visa lottery that happens every year. Not all countries are eligible, but many are. That would be another way to sort of permanently try to make that transition to the U.S. For most people, it's going to be through family or through a job. And once you come here to the U.S., typically on a non-immigrant visa, you will then transition through to permanent residence. And that would be the most likely path that you would have to follow if you wanted to make a permanent move to the United States. Chad, this next question was one of my favorites. I'm going to throw it to you.
It definitely wins the category of the briefest, I think. F1 visa. So
yes,
an F1 visa it's a student visa. So somebody coming from another country applies or enrolls at a U.S. university. If they're admitted, that university will help their sponsorship with the F1 visa. Once they get that approval, they can apply for the visa stamp in their home country, travel to the United States, and begin going to school. while you're going to school, you can actually potentially qualify for work authorization. Typically, this is part-time. It's called CPT, Curricular Practical Training. So you can work while you're going to school. And then again, as we've talked about, after you graduate, if you get a 1-year work authorization of OPT, or if you're in a STEM field, you can get up to 3 years.
We have another question here. I'd love to learn about getting the O1 visa and EB2 green card applications. We've talked a little bit about the O1. It really has a very high threshold. You either have to be sort of at the very top of your field, recognized internationally in what you're doing. Typically, these are people who have a PhD and a significant number of publications, lots of citations. A lot of times these people will work in research positions. Not always required. There are ways you can do it through business or through other fields. You just have to have like a real international reputation to qualify, be working with an organization that has a good reputation, command a high salary, and sort of have the recognition of your peers. And on this question, when it asks about EB2 green card applications, I'm going to make an assumption that it's asking about the national interest waiver classification. And a couple of things on that. One, if you are in a position where you work in a job that potentially has benefits for the United States as a whole, you could potentially qualify for the national interest waiver. There are a bunch of criteria that need to be met. Chad and I did a video a few weeks ago talking specifically about self-sponsorship options. We spend a fair amount of time on NIW, and I would encourage you to check out our YouTube channel and look for that video. That'll provide some helpful information. Additionally, if you have specific questions about your case and want to explore the EB2 NIW or an O1 petition, we'd be happy to set up a time to review your facts and your situation and your qualifications to see if there's a case to be made there.
So this next question is startup founder visa. I'm going to share my screen just for a second. The first thing to be aware of what we're really probably talking about here is an E2 visa. And I wanted to show you guys this website. So there's a website that shows you whether your home country is participating in the E1, E2 program with the United States. So as you scroll down here, if you see, your country, let's look at Bahrain, for example, here. If you see your country and it lists E2, that means that you're eligible, and you're from Bahrain, you're eligible for an E2. If you're applying for an E1, it's not listed, so you wouldn't be. If you look at Belgium as another example, you got E1 and E2. You could apply for either one, E1 or an E2. So you want to find your home country and see if you are eligible for either of these. The next thing to be thinking about with an E2, so first of all, you have to be from a treaty country. The next thing is you have to be making an investment in a startup, or you can be purchasing an existing business. So you have to be, investing money, actual monetary money. I was going to say dollars, but it could be a different currency, into a business that you're starting up on your own or that already exists. You need to own at least 50% of the business, and the investment needs to be considered not marginal. And what that means is, unfortunately, this is one of those areas where the government doesn't give us a specific amount, because this is always the question: how much do I need to invest? And if they said, well, $25,000 or $50,000, we would know and we could meet it. But because they don't put it, they just say that it needs to not be marginal. It's sort of open for interpretation. The ones that we see that are more successful are typically ones where the investment is at least $40,000 US dollars. If it's less than that, that's not to say that it's not going to qualify, but it's just we need to make a stronger legal argument in some of the other areas that they'll be looking at. And then the last thing is that the investment needs to be what they call real and operational. And what they're looking for there is that you're investing in the kinds of things that you would expect a new company to be investing in, incorporating the company, making lease payments, buying inventory, investing in a website, hiring employees. Those kinds of things is where they want to see the money actually invested to be considered a real and operational type of investment.
Chad, did you get nervous there? I got kicked out of the meeting for just a second.
Oh. I thought you were saying
Um,
because I wasn't covering the topic adequately.
Oh, no, no. I thought you actually did a really good job. And the next question that I was going to address asks specifically about E2 business plans for a consulting idea, which would be a low-cost startup. And the challenge here with this, and again, this is speaking very broadly, is we're going to have to demonstrate that there's a substantial investment being made. And that is somewhat in relationship to the cost of starting up a venture. But in a case like this, it's really hard to look at it and give any kind of estimate. But just know, like Chad said, I mean, the government is looking for a substantial capital investment, and that's going to be relative to the cost of an enterprise. And so this is the case where we'd have to sort of dig into some specifics a little bit more to really figure out what was likely to work or not.
The next one is on the same topic here, the E2. So the only we've talked about this. The only thing I will add is that the investment needs to be what's considered at risk. So it can't just be sitting in a bank account where you say, okay, we opened a bank account for this business, I put the money in, that's my investment. That won't work. They need to see that you've actually either spent the money or it is somehow committed in one way or another. And what they want to see is that you're actually making an investment that could succeed or fail. And if you fail, that you're going to lose your money. They want to see that type of a leap made in terms of what the investment is. The other couple of things I would say is if you're going to do this, you want to have a really solid business plan to show what your plans are. And one of the things they look for are plans to hire people. They really want to see that you're looking to hire workers and that you're going to be creating jobs within the United States. So that's another really important element for E2.
The next question is about obtaining an H4 visa for a spouse. And the good news here is that the H4 visa application process is fairly straightforward. If the spouse is currently in the United States, you can either apply for a change of status from whatever their current non-immigrant visa status is using an I-539, or if they're outside of the United States or plan to travel out of the U.S., they simply need to take evidence of your H1B status along with evidence of your marriage, a marriage certificate, and they use that to apply for the H4. They'll secure an appointment at the consulate and prepare and take those documents. They'll be interviewed, and that H4 will be granted solely based on the relationship, the marital relationship that exists with the H1B status holder. This next question is an interesting one. I have, and if I have an approved I-140 from previous employer and my current employer hasn't started my PERM application process, will I be able to travel to my home country for visa stamping and be able to enter into the U.S.? Most likely, yes. The answer here is most likely yes. Now, if you are on a strictly non-immigrant visa classification, TN, O1, E3, H1B1, you could face some issues when going to renew your visa because having an I-140 application potentially could show that you had an immigrant intent. If you're on an H1B or an L1, you're not going to have any issue at all. But if you're in one of those other categories, it's probably a good idea to talk to your attorney to make sure that you have adequate documentation to demonstrate that you're no longer pursuing that I-140 and that you continue to have a strictly non-immigrant intent. So H1B, L1, nothing to worry about. If you're in another classification, probably a good idea to just review and talk with an attorney to make sure that you don't go and get stuck outside of the United States.
Okay, international travel. My understanding is that during the I-485 phase of the application, you are not allowed or advised to leave the U.S. while on an O1 visa. Is this correct? Is there no other way to travel outside of the country without losing the O1? Are there any exceptions to this rule? Yeah, this is one of those really unfortunate things where there are rule carve-outs for those that are in H1B and L1 status. And so our advice is once the I-485 is filed, they should wait for the receipt notice, but then they can travel outside of the country still with their H or L visa stamp. That same carve-out does not exist for an O1. And so the advice is to remain in the United States until the advanced parole is issued. And unfortunately, that advanced parole right now is taking anywhere from 10 to 12 months. So it used to be a short period of time of just 2 to 3 months that you had to stay and not travel. But now with it taking so long, there's a long period of time where you're not supposed to travel. And unfortunately, if you do travel prior to getting the advanced parole, then it would be considered an abandonment of that I-485.
The next question is, if I go home, what is the process? Obviously, that's going to depend on specific circumstances, but if you're here on a non-immigrant visa and you need to travel internationally, you need to make sure that you have a valid passport and that you have a valid visa stamp for your corresponding current status in order to be able to return. For example, if you're in the US on F1 status and you have an F1 visa in your passport, you subsequently change your status to H1B, but you don't yet have an H1B visa stamp in your passport, you cannot return to the United States using that F1. You're going to have to apply for an H1B visa at the consulate where you're traveling in order to be able to return. You want to make sure that you schedule your consular appointment for the interview with plenty of advance notice, and that you give yourself, I say, at least a couple of weeks for the consulate to process your visa application from the time that you have your interview. So you do want to make significant preparation before you leave the United States. You'll want to make sure that you have all the necessary documents in order, that your appointment's all lined up. And again, we would encourage you just to double check with your attorney to make sure that you have everything you need when you travel so that you can avoid the possibility of being stuck outside the United States for a sometimes difficult to predict amount of time.
Next question says, if we move from the existing residential address to new residential address, do we need to update the information? Yeah, my advice is you need to let your law firm know, first of all, so that if they're sending anything to you, they're sending it to your correct address, and also to update U.S. Citizenship and Immigration Services. The form that you file, which you can do online, is called an AR-11. You update USCIS, and then if they send out any notice receipts or other notices, that should theoretically come to your new address if you do that properly. So notify your law firm and USCIS.
This question, when do you need to apply for an extension? It's permissible to apply for an extension as early as 180 days before your current documentation or I-94 card expires. We recommend filing as early as possible. And at our firm, we're initiating those extensions right around 7 months in advance to give us time to gather documents and get everything ready so that we can file right at that 6-month mark. You can file right up until, technically the application could be received, I think, the day before the expiration. I would hate to cut it that close, but our recommendation is that you get that application in 6 months in advance.
L1 and later EB1C filing based on my own corp in Canada and US. Okay, so L1A is a work permit for what's called intra-company transferees. So these are people who work for a company outside of the United States at an office in some other country, and then they transfer, that same company has an office in the United States, and they transfer from that office outside the United States into the United States. You can either come as an L1A, which is a manager or executive, or an L1B, which is somebody who's considered to have specialized knowledge. EB1C is a multinational manager application within the green card process. It's in the first preference category. So as we've talked about first preference category previously, we talked about extraordinary ability and outstanding research. Here, by virtue of having worked for the company outside of the United States in either a manager or executive role, and then transferred to the United States as a manager or executive, means that the person can file for a green card under the first preference category. So the benefits there are skipping the PERM labor certification, and then also being able to benefit from the better priority dates under the first preference category. So EB1C is great if you can qualify for it. And congratulations to whoever wrote this question. You're in a great spot.
The one sort of trick there with that one, though, I think is the, own corporation and how ownership could potentially impact that, and, maintaining operations in both countries would be really important too, I think. So definitely need to have ongoing entities in both locations. I would like to know how long a citizenship application process will take and if it's possible to travel abroad back to our home country during the process. Thanks. Citizenship applications take, on average, around 12 months. It varies really by the local jurisdiction where you live. Those processing times are available online at myuscis.gov. It gives you a pretty good sense, but on average, it's about a year. It is permissible to leave the United States while your naturalization application is pending. The only kind of, well, two caveats on that. One, if you've spent a lot of time outside the United States, it's important to keep in mind that you have to have spent at least half of your time in the U.S. as a permanent resident in order to be eligible for naturalization. So if you're spending a lot of time outside the United States, you want to make sure that you're maintaining or meeting that ongoing residency requirement. The other thing is if you're going to be gone for more than a couple of weeks, you probably want to have somebody checking your mail to make sure that you don't get notifications of an interview. Those will often come with as little as 2 weeks notice for your naturalization interview. And you'll want to make sure that you're able to be here, and if not, to reschedule those applications. So definitely possible, but want to make sure that you're keeping an eye on those residency requirements.
This is officially our last question. So with the time we have left, which I know isn't a lot, we'll go ahead and get to the questions in the chat, but I'll answer this one first. I want to confirm the process of removing conditional green card status. So the form that you file to do that, and the way this attaches is through the marriage-based immigration process. If you've been married for less than 2 years, you'll get most likely a conditional green card. Then you file the form I-751 to have those conditions removed. You must still be married. There are certain exceptions to that, but typically demonstrating that you're still married to your spouse is an important piece of that. In terms of when to file, you need to file during the 90-day window right before the expiration of the card is when you make that application. And right now it's currently taking anywhere from 12 to 18 months. I assume that the question was about the family-based process. There is also removal of conditions for those who file through the EB5 investor category, and the form for that is an I-829. But I'm not going to go into a lot of detail because I assume this is the marriage-based process. So with that, Sam, should we get to the chat?
Yeah, Chad, I'll go ahead and take this first question. As far as I understand, if my husband qualifies for H-4 EAD, he can apply for a Social Security number using Form I-765 along with a pending I-140 immigrant petition that we have. Almost. The I-140 needs to be approved. Is that right? Do I have that right? Oh, see,
Oh, sorry.
now I might have stumped myself. Does the I-140 have to be approved in order to qualify for that H-4 EAD? I feel like it does.
I think it does, yeah.
I'm fairly certain. So once that I-140 is approved, yes, your husband will be eligible to apply for an H-4 EAD, assuming that your priority date is not current. If it is current, then you're going to need to apply through the adjustment of status process for him. But you could do that, while that I-140 was pending even. So yes, options there for sure.
Okay.
I think I had gone all the way to the top, but maybe I didn't. Oh, I did. Okay.
So the next question says, hello, if my green card process is started through EB2, but if I may qualify for EB1 later, can that be changed? The answer is yes. If you have an EB2 pending, my guess is that you have not filed the I-485 yet, but you're waiting for a current priority date. So then if you get to the point where you qualify for the first preference category, you would file that new I-140. And once that got approved, then you could base the I-485, that third step in the green card process, on the first preference category dates rather than the second preference category dates.
Great. And there was a question that we actually had skipped here, and it's a naturalization question. I have a green card now. To keep it alive, I travel less than 6 months abroad. If I'm in the USA approximately 6 months each year, does that account toward 5 years wait time for citizenship? Maybe. You're going to have to demonstrate that you are actually maintaining residence in the United States. And so I would encourage you to look up, the USCIS has guide for naturalization eligibility online on their website. You can Google search that. It's a really good resource that will help clarify specifics about your case. You may need to spend a little bit more time in order to keep that clock like going the right direction on the 5 years, but yes, you should be very close to being able to do that. All right, Chad.
Great. I have 3 published papers and 1 patent. I did my master's in India. Am I eligible for EB1? I would say based on this, you're not quite there. This is a great example of somebody I would say it's worth continuing to publish research, continue to seek potential opportunities to do reviews of articles or to get into organizations. Peer reviews alone are not great evidence, but if you're on like an editorial board or you're making decisions on which articles are getting published, that's better evidence. So, I would say to this individual who asked this question, feel free to reach out to us and we can give you a little bit more guidance on some of the things that you can go for. But I would say you're well on your way, but maybe not quite there based on this alone. The next question, the same one says, my son turned 19 and I don't have a green card yet. Is it okay for him to move into F1 visa? Yes, that's fine.
All right. The next one is it worth upgrading from EB3 to EB2 category for India? Hard to say. It really depends on where your priority date is. If you are eligible to do the upgrade, it may be worth exploring. I wouldn't feel a ton of pressure to do that until your priority date is, within 3 or 4 years probably of becoming current. But certainly we have lots of clients who have done upgrades or downgrades in order to try to take advantage of priority dates as they jump around.
Next question says, are there any specific periods during the PERM approval or I-140 filing process when traveling outside of the U.S. is not permitted? The answer is no. As long as you have a valid, let's say, H1B visa stamp or whatever your status is, visa stamp, you can continue to travel. The time that it may be restricted is at the 3rd stage of that I-485.
You know what? And I think right there, well, should we try to get one more? We kind of answered that F1 question. I'm looking for one we can answer in the amount of time we have. Stephen Allred put some very helpful information here in the chat about the visa bulletin.
Thanks, Stephen.
Okay, here's one that I like that I think is a good question that comes up a lot. Can an applicant change jobs titles within or out of the company after PERM is approved and during AOS timeline? This is a tricky one because you, in theory, potentially could. If you have a PERM that's been approved, an I-140 that's been approved, and your adjustment of status has been pending for 180 days, you may qualify for what's known as portability under AC 21, and that could allow you to change employers and take your entire green card application to a new employer as long as you're working in a similar job to the one that was described in your I-140 application. So potentially that is an option. I very rarely see people change employers while they're in the green card process of their own volition. Most of the time what happens is they're looking to move that green card to a new employer if they've been let go or their job has been eliminated. Chad, I think unfortunately we're out of time. I do just want to give the disclaimer here one more time. Nothing that we've said here is really legal advice. This is all informational. If you have specific questions, please reach out to us, reach out to your own immigration attorney. We want to make sure that you get something that's very specific to you, but hopefully this has been helpful. Thanks everybody for your time. Have a great rest of your day.
Bye, everybody.